Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I'll be joined by my colleague, Ed White, a partner in our intellectual property practice group here at Williams Mullen, and we'll be discussing BREXIT and its impact on copyright rights and copyright portfolios. Ed, how are you doing today?
I'm doing well, thanks, Janet. How are you?
I'm doing well. I think this is an interesting topic. It's going to be fun.
It is, and I think it's timely too as we head to the year end here.
Yep, absolutely. And I just woke up to the fact that it's almost October, so we're definitely getting closer to, the operative point of Brexit. But before we talk about copyrights, I thought it might be helpful for everyone listening to just go over, generally speaking, what Brexit is, so that everyone has a little bit of context and some important facts about what Brexit is. So, with that, before I actually talk about Brexit, one thing I wanted to explain, because it's an important part of the Brexit discussion, is what exactly is the EU, or also known as the European Union. And the EU is a political and economic union of 28 countries that basically trade with each other and have other benefits, such as allowing citizens to move easily between the countries to live and work. So you have relatively porous borders. And so it's really a collaboration or a grouping of countries that basically offer each other some preferential benefits to allow for trade and cultural exchange. And back in 1973, the United Kingdom joined the EU. And now that we talk about Brexit is essentially an amalgamation of Britain exiting the EU. So we in common parlance call it Brexit. And what Brexit is, it reflects a referendum that took place back in 2016 when voters in the United Kingdom or the UK were essentially asked one question, which was whether the UK should leave or remain in the EU. And the outcome of the referendum was that UK voters decided to leave the EU. So since 2016, there have been, and I'm speaking very generally because a lot has happened between 2016 and today, but basically there has been a lot of discussion between the UK government, the EU, to essentially decide on how this exit is going to occur, because there's a lot at stake on both sides. And so technically the UK did leave the EU on January 31st, 2020, but we're currently in a phase called the withdrawal agreement, and that is going to extend until December 31st of this year. And during this withdrawal agreement phase, basically the UK is working with the EU authorities to basically hammer out how this exit is really going to sort of take place in practical terms on January 1st of 2021. So the way I like to describe it is, even though the UK did legally leave maybe on the 31st of this year, they will actually practically fall out of the European Union on January 1st of 2021. And with that, there are going to be a lot of implications for IP rights holders, including copyright holders or those who are seeking copyright rights in the UK and potentially the EU. So, and that's what our discussion is going to focus on today, is specifically the issue of copyright rights and what will Brexit do? How will Brexit impact current copyright holders and potentially those who are seeking copyright rights in the future in the United Kingdom? So with that, Ed, I think your expertise would be definitely necessary here. If you can let our listeners know, how are copyright rights ascribed or granted in the United Kingdom, and how similar is it to the United States, if at all?
Sure. Well, thanks, Janet. As many of our listeners may know, it's interesting that U.S. copyright law and UK copyright law have developed in some respects similarly, and the laws are similar in many respects. Copyright law in the UK originates from the common law, and that common law has been codified over time in several statutes, including the Statute of Anne back in 1709, the Copyright Act back in 1911, and the current Copyright Designs and Patent Act which the UK enacted in 1988. And similar to US copyright law, UK copyright law gives creators of various works the ability to control the ways in which their material may be used, performed, etc. And some of these works, similar to the US, include literary works, dramatic works, musical works, artistic works, and typographical arrangements, as well as sound recordings and film. Similar to US copyright law, in the UK, copyright is an automatic right that arises when an individual creates a work, which is an original expression of an idea. So in essence, when we talk in the US about fixing something in a tangible medium and common law copyright rights rising at that point, the same is true in the UK.
Well, thank you, Ed. That was very helpful. And one thing I wanted to raise, because it's something I think a lot of our listeners might come across, but and it's a phrase that we may have heard of, but we don't really know what it means, is the issue of moral rights. So could you talk a little bit about, what moral rights are and perhaps, what is their role or how they're treated, if at all, under the UK copyright law?
Yeah, I'm glad you brought that up, actually, because moral rights are sometimes a little bit of a sticky point, especially for our U.S. clients, since we really don't recognize moral rights per se here in the United States. Moral rights are statutorily conferred in the UK's Copyright Designs and Patent Acts. That's the most recent one that was enacted in 1988. And oftentimes, moral rights are thought of as non-economic rights of the copyright creator. And they comprise a few different things, but the main points are they allow the copyright creator or the artist to have the right of attribution. So in other words, they have the right to be identified as the original author of the work when the work is copied or communicated. They have the right to object to false attribution. So if they're named as the creator of a work and they're actually not the creator of a work, they certainly have the right to speak up and correct that. And they have the right to control the form of the work. So in other words, if the work is created and then published in such a way that it impacts the integrity of the work or creates the work in a derogatory manner, moral rights enable the artist or the originator to control that as well. So, again, moral rights are something that is, I guess I would call it another layer of copyright protection that artists and creators have in the UK that we don't necessarily recognize here in the US.
Thanks, Ed. I think that's very helpful. I think my sense of moral rights is they're all rights that at least we in the United States have heard of or are familiar with. Perhaps we just don't always realize they're referred to as moral rights. So now we can use the buzzword when we come across these rights. Well, one thing you mentioned is that in the UK, similarly to the United States, is that copyright rights arise automatically. I believe you had mentioned, but we do have in the United States a mechanism to register copyrighted works. Do parties in the UK register copyrighted works as well? And is there any benefit to it?
Yeah, that's another interesting point, Janet. There actually is no formal register of copyrighted works in the UK. So as you said, here in the US, a copyright owner can bring their copyrighted work to the Copyright Office and obtain a copyright registration. And in the US, as you know, having a copyright registration is really a prerequisite to bringing a copyright claim under the Copyright Act here in the US. And it's a prerequisite to being able to assert statutory damages in an actual infringement case. So there are reasons certainly here in the US as to why you would want to bring your work to the Copyright Office and obtain a registration. In the UK, again, there is no formal register. However, there are commercial filing services that do exist in the UK. And so these are essentially commercial companies that will take from a copyright owner a copy of the copyrighted work. They will issue, I guess, quote unquote, a registration. And then that registration enables the copyright owner to be able to assert, more effectively an infringement case that they own the work, when the work was created, and that enables them to certainly be able to bolster an infringement claim that they may bring against an infringer. And again, that's done through commercial entities in the UK. but there is no governmental per se authority that provides that registration.
Thanks, Ed. That's actually very interesting and, somewhat of a big difference when compared to the United States. So now that we've learned, some of the similarities and differences between the United States and UK systems, and with Brexit pending or impending on all of us, what effect do you believe Brexit will have on UK copyright law?
Right. Well, as we've discussed a little bit already, much of the UK's copyright law has its roots in international treaties, such as the Berne Convention. It certainly has its roots in the UK's common law and in the UK's copyright laws as they are codified. And so they aren't dependent per se in the UK on their membership in the EU to provide UK citizens or UK copyright owners with their legal ability to maintain or enforce copyrights. But there are many aspects of current UK copyright law which are derived from EU directives. So you had a really great introduction about what the EU is and how it functions. EU directives, you can essentially think of them as statutes that are adopted by the EU membership, and then they're expected to be enforced by the EU members. Now, up to this point, many of the EU directives have been incorporated or encapsulated in UK copyright laws. And as of December 31st, when the transition period ends on the withdrawal agreement, the hope in the UK is that the EU directives up to that point will have been incorporated or codified in UK law. And so, there's a hope that there won't be a great deal of change in UK copyright law as that's seen, versus EU copyright law immediately following the end of this transition year. But as you might expect, as time passes following Brexit, it's certainly plausible that the UK may not incorporate subsequent developments in EU law regarding copyrights, and they may not be added EU directives to UK copyright laws. And one example of that I have actually currently is that the EU is in the process of looking at the European Union directive on copyright in the digital single market. It's an EU directive that's being debated right now among EU members. And it really is an EU directive that discusses how copyrighted content is shared in online platforms. The directive on copyright, in this case, its most controversial component is Article 13. And Article 13 of this proposed directive requires online platforms, such as, let's say, YouTube or Google, et cetera, to filter or remove copyrighted material from their websites. And obviously, if they have permission to use them, they can. But there really is not going to be any fair use, per se, as we know of it in the United States. And this is the article that most people think will be most problematic because they see it, for example, as a ban to any memes or informational uses of copyrighted materials. Now, the UK has already stated that they will not adopt Article 13 should it be enacted by the EU. It will not be part of UK copyright law going forward because the UK feels the directive is going to have a chilling effect on information sharing through the internet. So this is a really prime example of something that's being considered in the EU right now, but likely will not be added or codified to UK copyright law. So you can see where there may be some divergence in the future as far as legislation goes. It's also, I think, important to note that the Court of Justice in the EU, which oftentimes will issue decisions on copyright infringement and copyright law, those decisions will no longer be binding upon UK courts post-Brexit. So while those decisions from the EU Court of Justice may be suggestive or probative or persuasive authority in the UK, they will not be required to follow the precedential value of those decisions. And I will just kind of double back and say that it's also worth noting that the UK may develop copyright law unilaterally in the future. So not only will the divergence be perhaps what is the EU adopting, is the UK adopting it or not, but the UK themselves may have some independent copyright law that they unilaterally develop in the future that the EU may not incorporate in its directives over time. So again, the divergence is there. Now, I will say that even if there is divergence post-Brexit, I will just say that people should be comforted by the fact that the UK has already harmonized much of its copyright law via international treaties such as the Berne Convention. So I don't expect this divergence to be of great concern to U.S. copyright owners who may have wish to enforce copyright rights in the UK. But it is worth noting that the UK and the EU really won't be necessarily on the same page in the future.
Thanks, Ed. That was a really great explanation. And I think your comments really reflect that some things after December 31st, 2020 will be markedly different. Other things may stay the same, and some things may really be in flux right up until the last minute as we approach December 31st. So with that, and I think we still, even though there's only a few weeks left to go in this transition period, I know there's a lot to still be considered. So knowing all of that, what should U.S. businesses or U.S. clients consider as we approach the end of the Brexit transition period with regard to copyright rights in the United Kingdom?
Yeah, I think the key thing will be to keep in mind that the UK is a separate jurisdiction from the EU. I think intellectual property lawyers in the U.S. oftentimes will utilize UK firms. There's a familiarity, obviously, in language and custom that makes it easier, oftentimes, to use UK firms to provide not only advice and counsel on UK matters, but also on EU matters. That may not be what we can do going forward. And that's just an example of trying to remember that these are two separate jurisdictions now, and they needed to be treated as such. I also think that, U.S. clients who have copyright rights that they want to enforce in the UK and the EU for that matter, will need to consider how they go about doing that. Will they have a holistic strategy where they look to try to protect something in the EU and then separately in the UK? Will they look at it from a national perspective where they look at individual countries? Or will it be some hybrid of that? So again, it kind of harkens back to the fact that we have separate jurisdictions here. But I do think that that's part of the strategy or it should be thought of in the strategy that people use when they are obtaining and enforcing copyright rights in the future.
Thank you, Ed. I think you definitely underscored the most important issue of Brexit, which is that going forward, the UK will indeed be a separate jurisdiction. And so some of the things you might have been used to or perhaps relied upon when the UK remained a member of the EU is something, we'll all have to reconsider and plan anew for. So with that, thank you, Ed. And that will wrap up our discussion about Brexit and its impact on copyright rights and copyright portfolios. I'd like to thank Ed White for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thank you for listening, and until next time.